There's a rule they never print on the CDL when they hand it to you. The license doesn't clock out when you do. A driver can run 30 years without a single ticket in the truck, pass every inspection from Tucson to Trenton, and still lose everything over something that isn't even against the law. Not one habit on this list will get you arrested at the scale house. Most of them are things drivers do every single week without thinking twice. But every one of them has ended careers, and number one has taken more CDLs than every roadside inspection in America combined. Back in the golden era, the job and the man were two different things. What a driver did in his own car, his own time, and his own medicine cabinet was nobody's business but his. Those days are gone. Today, a commercial license comes with a federal file, a drug testing clearinghouse, and a standard that follows a driver home, into the pharmacy, and out to the bar on Saturday night. These are the 15 legal habits that can still take it all away. Number 15. Logging the pre-trip as off-duty. Every old hand knows the morning routine. Coffee in one hand, flashlight in the other, a walk around the rig kicking tires and checking lights before the sun's up. Perfectly legal. Required, in fact. The habit that kills drivers on paper is where that time goes in the log. For decades, drivers marked the walk-around as off-duty or skipped logging it entirely because 15 minutes of on-duty time felt like giving hours away for free. Under electronic logging, that little fudge is falsification of a record of duty status, the same violation category as the old comic book log books. An auditor who sees a truck moving 4 minutes after a driver came on duty knows no real inspection happened, and the engine control module backs him up every time. Fines run into the thousands per occurrence, and a pattern of it invites a full compliance review of the whole carrier. Logging the walk-around honestly costs 15 minutes. It's the cheapest 15 minutes in trucking. Number 14. Cold medicine before a night run. There isn't a truck stop in America that doesn't sell the green nighttime syrup right next to the register, and there isn't a law against buying it. But the federal rules say a driver can't operate while impaired by any substance, and that includes the perfectly legal stuff. The old nighttime formulas carry alcohol and antihistamines that hit a tired man like a hammer, and an officer who smells it on a driver's breath at 3 in the morning doesn't much care that it came from a pharmacy shelf. Worse are the prescription-strength cough syrups with codeine in them, because codeine is an opiate, and an opiate shows up on a DOT drug screen looking exactly like the illegal kind. A driver who tests positive gets pulled from the road and lands in the federal clearinghouse before he can explain his head cold. The old hands had a saying about it. Sick enough to need the syrup, sick enough to park the truck. Number 13. CBD at the fuel counter. Walk into any travel plaza today, and there's a rack of gummies, oils, and sleep drops right by the beef jerky. All of it legal under federal farm law as long as the THC stays under 0.3%. The catch is that nobody regulates what's actually in the bottle, and study after study has found products running hot way over the label. A DOT urine test doesn't ask where the THC came from, it just finds it. And a positive marijuana test for a CDL holder means immediate removal from safety-sensitive duty, a flag in the FMCSA clearinghouse that every future employer sees, and a return to duty process with a substance abuse professional that can drag on for months. The federal government has been blunt about it. CBD use is not a legitimate medical explanation for a positive test. A $10 bag of sleep gummies has taken down more drivers than most people would believe, and not one of them ever felt so much as a buzz. Number 12. One touch of the phone. Hands-free is legal. Bluetooth in the headset, phone mounted on the dash, voice commands all day long. But the moment a commercial driver reaches for that phone, holds it, or dials it by hand, he's crossed into a federal violation, and the rule applies even sitting dead still in a traffic jam on the Cross Bronx. The fines climb to $2,750 for the driver and over $11,000 for a carrier that allowed it. And the part that surprises people is the disqualification schedule. 2 convictions inside 3 years, and the CDL is suspended for 60 days. 3, and it's 120. Officers sit on overpasses with binoculars now, and a phone in the hand at 70 miles an hour is visible from a quarter mile. The old CB mic never counted, which tells you something about how the rules were written. Talking was never the sin. Looking down was. And the phone isn't even the most dangerous thing on that dash. The most dangerous thing on the dash is the map. Number 11. Trusting the car GPS. There's no law against running Google Maps in a Peterbilt. Plenty of drivers do it every day, and most days it works fine. Then it routes a 13-foot-6 trailer toward an 11-foot-8 railroad bridge in Durham, North Carolina. The one so famous for peeling trucks open like sardine cans that it has its own camera and its own fan base. Or it sends a rig onto a New York parkway where commercial vehicles have been banned since the Roosevelt administration and the stone overpasses were built low on purpose. A bridge strike is almost never ruled anything but preventable, and after one, the driver is looking at state charges, a civil bill that can run 6 figures, a CSA record in ruins, and a resume no safety manager will touch. The truck-specific GPS costs a few $100s. The regular one costs the roof of the trailer and sometimes the career underneath it. Number 10. Stretching personal conveyance. The rule itself is a gift. A driver who's out of hours can still move the truck off duty for personal reasons, finding food, finding parking, getting to a motel. But the line between personal and business is thinner than a logbook page. Use that off-duty status to creep 60 miles closer to tomorrow's receiver, or to bounce an empty trailer back toward the yard, and it stops being personal conveyance and becomes falsification. Auditors pull the personal conveyance lines first now because they know exactly how the game is played, and a pattern of long off-duty drives that always happen to point toward the next load reads like a confession. The violation carries the same weight as the old second logbook, thousands per offense and a driver's record marked for years. The freedom is real. The rope it hands you is too. Number 9. Prescription meds without the examiner's blessing. This one catches good, honest drivers by the hundreds. A doctor writes a legal prescription for pain, anxiety, sleep, or blood pressure. The driver takes it exactly as directed, and he figures that's the end of it. But a CDL runs on a DOT medical certificate, and the medical examiner has to know about and clear every medication in the cab. Opioid painkillers, benzodiazepines, certain sleep aids, and some seizure and diabetes medications can all disqualify a driver or require a letter from the prescribing physician saying the man is safe behind 80,000 pounds. Fail to disclose it, and the medical card itself can be invalidated, which makes every mile since the exam a violation. And if a drug screen turns up an opiate the examiner never heard about, the driver is treated like he failed, prescription or not, until the paperwork catches up. In the old days, a man's medicine cabinet was his own business. The federal government disagreed, but at least a prescription leaves a paper trail a driver can straighten out. The next habit trips drivers who did everything right and never even knew they were illegal. Number 8. Doing the sleeper split from memory. The split sleeper rule is legal, useful, and one of the last pieces of flexibility left in the hours of service. A driver can break his 10-hour rest into 2 pieces, 7 and 3 or 8 and 2, and pause the 14-hour clock in the middle. The trouble is the arithmetic. Picture a driver outside Columbus who takes 8 honest hours behind the sleeper berth curtains, runs his morning, grabs a 2-hour break at a rest area, and pairs it in his head with yesterday's split instead of today's. He rolls up to the scale house convinced he's legal, and the officer scrolling through the ELD screen finds an 11-hour violation sitting in plain sight. Confusion is not a defense. The violation lands on the CSA record, the carrier's score takes the hit, and enough of them stack into an out-of-service order. Old-timers who learned hours of service with a pencil will tell you the paper version was easier to bend, but also easier to understand. The electronic clock forgives nothing, including good faith. Number 7. Sleeping on the ramps. Drive any interstate at midnight and you'll see them. Trucks line nose to tail on exit ramps and shoulders from Pennsylvania to Wyoming, hazards blinking in the dark. The parking shortage is real. There's one legal spot for roughly every 11 trucks that needs one, and when the 14-hour clock runs out, it runs out wherever you are. Shoulder parking sits in a legal gray zone that troopers tolerated for decades, but the tolerance is gone in a lot of states now. The citation stings, but the real danger is liability. A parked truck struck on a shoulder at night drags its driver into a lawsuit no matter who was at fault, and courts have hung negligence on drivers just for being parked where they were. So the smart money shuts down early to grab a real spot, and shutting down early means a long night in a cold cab, because the anti-idling laws don't care that you parked legally. That's the corner a lot of drivers have quietly engineered their way out of. More than a few keep a thermal bivvy stashed in the side box or the bunk, and the name that keeps coming up is Terra Shell. It's a compact emergency sleeping bag with an aluminized lining that bounces your own body heat back at you, so the bunk stays warm enough to actually sleep with the engine dead in freezing weather. Folded up, it's smaller than a soda can. Nothing to fuel, nothing to charge, you shake it out and climb in. Weigh that against one night parked on a shoulder waiting for trouble, and the math takes about 2 seconds. There's a link in the description if you want to see it. Now, solving a cold night with your own 2 hands is the oldest tradition in trucking, which is exactly how drivers get in trouble with the next one. Number 6, adjusting your own brakes. For 50 years, this was just Saturday morning. A driver crawled under the trailer with a wrench, took up the slack and rolled on. It felt like changing your own oil. But federal rules say brake work on a commercial vehicle has to be done by someone who meets the brake inspector qualification. With training or experience, the driver has to be able to prove. A well-meaning adjustment done wrong can leave a brake out of spec, and brakes are the #1 out-of-service violation in America. When the inspector at the scale finds 20% of the brakes out of adjustment, the truck parks right there. The violations rain onto the CSA score. And if the paperwork trail shows an unqualified hand did the work, the carrier eats a fine on top. 50 years of Saturday mornings, undone by one line of paperwork nobody knew they needed. Number 5, signing for a load you never saw. Sealed trailer, shipper loaded, driver signs the bills and rolls. It's been standard practice since the golden era, and no law stops a driver from trusting the dock. But the weight ticket at the scale doesn't ask who loaded the trailer. The driver owns the gross, the axle weights, and the securement the moment the wheels turn, and overweight fines in states like New York and Pennsylvania scale by the pound, which means a shipper's forklift mistake can hand a driver a 5-figure ticket for freight he never touched. Worse, if that badly loaded freight shifts and puts the truck on its side coming down a grade, the accident is his, the CSA points are his, and the lawyers come for his license, not the dock foreman's. Veteran drivers learn to scale every questionable load at the first CAT scale they passed. $10 buys a lot of certainty. Number 4, speeding tickets in the family sedan. This is the one that shocks new drivers most. A CDL holder who gets popped doing 15 over in his own pickup on a Sunday afternoon takes that violation onto his commercial record, full stop. Federal law flat out bans the old courtesies. No traffic school to hide it, no deferred adjudication, no masking of any kind for a commercial license holder, even when the ticket has nothing to do with a truck. And the disqualification math is brutal. 2 serious violations in 3 years and 15 over counts as serious means 60 days without the CDL. 3 means 120. A driver can be flawless in the truck for a decade and lose his paycheck over how he drives to church. In the golden era, what happened in the four-wheeler stayed in the four-wheeler. The federal government ended that arrangement, and most drivers found out the hard way. But a speeding ticket only follows a driver back to work. This next habit can follow him into a felony courtroom. Number 3, the pistol in the cab. In most of trucking America, keeping a legally owned handgun in the truck is as normal as the thermos, and in the driver's home state, it's usually perfectly lawful. The trap is the map. A permit from Texas means nothing in New Jersey, and a driver rolling through New York or Illinois with that same pistol can be looking at felony charges that carry mandatory time. There's a federal transport law meant to protect travelers passing through, but it's written narrow, unloaded, locked away, no stopping over, and prosecutors in the strict states read it narrower still. And a felony conviction doesn't just mean a lawyer bill. It means the hazmat endorsement is gone, Most carriers won't touch the application, and depending on the charge, the CDL itself can follow. Plenty of drivers with clean records and clean intentions have learned this at a weigh station in the Northeast. The gun was legal, the zip code wasn't. Number 2, putting off the random. When the message comes down that a driver's been selected for a random drug test, the natural instinct is to finish the day, deliver the load, grab a shower, swing by the house, and hit the clinic tomorrow morning. That instinct has wrecked good drivers by the dozen because under federal rules, delay is refusal, and a refusal is treated exactly like a failed test. Same clearinghouse entry, same removal from duty, same return to duty gauntlet with a substance abuse professional before a driver can touch a truck again. It doesn't matter that the driver was clean as creek water. The clock started when the notification landed, and every hour after it looks like a man buying time. Drivers have refused by accident, by stubbornness, and by simply not understanding the rule. And in that database, a man who stopped for a shower and a man with something to hide look exactly the same. And that brings us to number 1, the legal habit that has taken more commercial licenses than everything else on this list combined. A few beers on a Saturday night, not in the truck, never in the truck. In the personal car, off duty, off the clock, on the driver's own time, which for 100 years was the most legal thing in America. But a CDL holder who blows over the limit in his own four-wheeler loses the commercial license for a full year on the first offense, even though no truck was within 50 miles of it. A second offense, and the disqualification is for life. And in the truck itself, the bar drops to half the standard limit, low enough that a couple of beers at dinner can end a career at the next inspection. The old hands remember when a Friday night at the tavern and a Monday morning behind the wheel were two different worlds. The law fused them together, and every year thousands of drivers who never once cheated a logbook or dodged a scale lose it all in a four-wheeler half a mile from home. Look at that list as a whole, and the pattern is hard to miss. Not one of these habits was ever outlawed. The government didn't need to ban them. It just tied every one of them to the license, so the rulebook rides home with the driver, sits at his kitchen table, and follows him to the pharmacy and the bar. The old-timers who ran the golden era answered to a scale house and their own good sense. Today's driver answers 24 hours a day, whether the wheels are turning or not. If you're living under these rules right now, or you ran in the era before them, tell us in the comments which one of these caught you or somebody you know off guard, because this list barely scratches the paint. And if these stories hit home, hit subscribe, because next time we're covering the unwritten rules of the CB radio, the code of Channel 19 that no school ever taught and no rookie ever learned fast enough. Keep the shiny side up.